First matter to come before us this morning is State of Ohio versus Darius E. Taylor. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If the appellant wishes to reserve any time, I'm keeping track of the clock, and you can also note that it's on the wall over there. But if you let me know when you get started, it just helps me keep the pace of the argument on our end here. These arguments are being recorded, and they will be posted on the court's YouTube channel, so please keep your voice up and remain behind the podium during your oral argument. Please don't use the names of victims or minors. As I just indicated, this will be posted on the court's YouTube channel. The judges have read your briefs. We're ready to see when you are.
Thank you, Judge.
Attorney Rayleigh, would you like to reserve any time for rebuttal today?
Yes, I'd ask for 5 minutes
Okay.
if necessary.
Thanks.
May it please the court, good morning, judges. My name is Rick Rayleigh. I'm appearing on behalf of the appellant in this case, the State of Ohio, and now Summit County Prosecutor Sherry W. Walsh. This is an appeal from the trial court's order that denied a motion to amend made on the morning of trial. The amendment was one such that the state requested to amend an F.2 possession of a fentanyl compound in combination with another controlled substance to an F.3 aggravated possession of drugs for possessing methamphetamine. It's the state's position that the trial court should have granted that motion, and we're asking today that you reverse the trial court's order to the contrary. So this involves a pretty common scenario that we see in common pleas, where initial field testing of a controlled substance shows one thing, and then a later report comes from BCI indicating it's another controlled substance. This is a very particular version of that, though, in that the first initial testing shows fentanyl as a type Schedule 1 or Schedule 2 controlled substance, and one that just shows the Schedule 2 substance of methamphetamine. That very particular, based on this different statute, I believe that Davis does not apply, and the trial court could have allowed an amendment.
You believe it doesn't apply because it was an amendment up?
It was an amendment down. That's number one.
I mean, yours was an amendment down, but in Davis it was an amendment.
Oh, yes, that's correct, yes. And this court has recognized that distinction before from Davis, in the Timothy case in particular that's cited in the materials. I'd also say for this particular drug offense, the entire reason that Timothy and those other cases hold that an amendment to a lesser included offense is appropriate is because the grand jury has already necessarily considered evidence and facts that lead to their charge within the lesser included offense. That's what happened here with this particular subsection of the statute. The grand jury received a report that this substance that was possessed contained fentanyl and another controlled substance that was Schedule 1 or 2. Once the new report came in, it just showed only one of those was present. Same weight, does not change, the penalty does not increase penalties. So for that reason, I believe that an amendment is appropriate. I think a good analogy for this court to also consider is amendments from F4 grand theft to F5 theft. This court has previously allowed that as well. There have been previous amendments from F1 kidnappings to F3 abductions, still lesser included offenses. Those have been allowed as well. And also the 3rd District in Hook has gone from aggravated burglary F1 down to F2 burglary. Those have all been appropriate in those courts. So that is the sum and substance of our argument, and it primarily rests on the fact that in this case, there was no prejudice to the defendant. The defendant learned about this BCI report early in the case. They were aware that an amendment was forthcoming, and there's no...
Why were they aware? Is there anything on the record that tells us they were aware?
It was, in the record, I believe it indicates that the report was given in September 2021 and from the oral arguments.
Were there any hearings, a record of hearing before the trial court where the prosecutor said, oh, we're going to amend this at some point in time?
I don't believe that that's in the record, but they are oral arguments where that representation was made during the motion to amend proceedings before trial.
So we're assuming at this point that they must have known that the state was going to amend it.
There were representations to that effect, and I don't think there's anything contrary to say that representation was incorrect.
Just so I'm clear, how was that in the record?
From before the transcript that's provided from the argument before trial. Yes. So the lack of surprise here and the fact that it's a lesser included offense are critical. That's why Davis doesn't apply. And when you look through the trial court's order, the judge mentions, well, Davis doesn't limit itself to only going from lower offense to a higher offense. That's not how this court has interpreted the case since it's been issued. And I would point again to that Timothy case that we decided after Davis's issuance.
If we were to agree and grant and say the court erred, it still would be an abuse of discretion standard. We would be saying, yes, you may, if you choose to, court, permit the amendment, but they're not required to.
So I know that the brief that was filed kind of left up what the exact standard review here is. I would say it is abuse of discretion. I would say the court's order should say that it was an abuse of discretion to deny the motion on the basis that it did, and that it should allow the amendment as it was.
Why didn't it abuse of discretion when the prosecutor's office was aware back in September of 21, which is a different drug, and waited to the day of trial to do anything to amend? They could amend it at any point in the
Well, and part of the reason that there is a delay is because the defendant did vacate this for quite a period of time. Now, I will not say that it's the best practice to settle like this. However, this court's, it's not a CLE or a legal training exercise, it's about what the law requires. And I think in this very specific particular instance with these subsections, the law did not require a supplemental technical opinion.
Would not defendant not have been prejudiced because he would have been planning to go to trial with a improper charge, if you will, and expecting at some point to be able to have the defense of they're charging me with possessing fentanyl, and there's no fentanyl. That could have been his entire defense the whole time. Showed up the day of trial and say, oh wait, now you want to amend, and then rug and pull out from underneath.
So if it was strictly fentanyl that he was charged with originally, and the charge was possession of fentanyl-related compound by itself, I would agree with you. However, this is fentanyl with another controlled substance. So he knows already that there's two controlled substances involved in the indictment, and the final report only indicates one of them, so that we had to go forward on that one. And if there are no further questions at this time?
I have a question about the finality of this order. Can you speak to that?
So this is before you as a motion for leave, and it was filed as a motion for leave because if this amendment was denied, there was no further way for the state to go forward. By denying it, we could not go forward and try the case the way that it was presented. So we requested leave, we believe it was abuse of discretion, and it was provisionally granted.
But you could also refile,
Based on the fact that there is a speedy,
refile and have a new grand jury. There's, if,
based on speedy trial judge, I don't believe we can do that. That's
well,
why.
the statute of limitations is 6 years.
Oh, I believe they would argue that there would be a speedy trial violation based on that. If we got a supplemental.
Did the defendant waive his right to speedy trial in that case?
Not that I know of.
Is there a jeopardy issue?
There's not a jeopardy issue because the jury was never sworn, Judge. And with that, any other questions, Judge?
Seeing none, thank you.
Good morning. May it please the court. I'm Attorney Steve Garachnin. I was the underlying attorney for Mr. Taylor since the beginning of this case. I was court appointed on August 10, 2021. With that being said, we would ask that you affirm the trial court's decision in denying their motion to amend the indictment based under the plain language of Criminal Rule 7D. In a nutshell, this is a completely different drug, completely different penalties, and a completely different level of felony. Mr. Taylor was not on notice of the elements that the state needed to prove on the day of trial. Some of the questions you had for the state, they did not notify me that they were seeking to amend the indictment until the Friday before the Monday trial on July 25th of 2022. They were in receipt of the BCI since September prior to that date. They never sought to amend the indictment before that, and we even had a motion to suppress hearing in December of 2022 where they argued that the drug in question was in fact fentanyl.
And you had the BCI report back then too, correct?
I did.
So it's not inappropriate for a trial court to amend an indictment on the day of trial if you had the discovery back then, right?
I think it is improper for them to amend the indictment on the day of trial, as I was under the impression that we were going under the indictment as written. That's the function of the grand jury. Under State versus YSLAS, YSLAS, as I briefed, Section 10, Article 1 of the Ohio Constitution guarantees the accused that the essential facts constituting the offense for which he is charged be found in the grand jury's indictment. So, that being said, they were just trying to circumvent the grand jury's function. For whatever reason, we don't know what happens at the grand jury. They could have no-billed this case for whatever reason, based on the facts. I think my client was extremely prejudiced as they are changing the level of felony. I don't think it matters it's going up or down. I think it prejudices him more since it was going down, so that could have affected his bond. We went from a felony 2 with mandatory prison time under the statute to a felony 3, which only had presumed prison time. I think he would, speedy trial wouldn't have been an issue, as he may have had a bond where he would have been out rather than in custody for over 200-something days from what I recall in this case. So I think under Criminal Rule 7, State versus Davis does apply, State versus Weisslist does apply. Their argument that it is fentanyl and another controlled substance is disingenuous, as the statute reads a combination, as it even states in the actual indictment. It says that combination of a fentanyl-related compound and another controlled substance. The reason for that is fentanyl is highly addictive, a lot of overdoses for fentanyl, and the statute protects and increases the penalties when fentanyl is in place because of the risk of an overdose. The case in question here, Mr. Taylor was only in possession of methamphetamine. I can't reiterate it enough, but they're changing the name of the drug from fentanyl to methamphetamine, and they're changing the identity of the crime in violation of Criminal Rule 7 by changing the level of felony from felony 2 to a felony 3.
The state asserts that they're not changing the name of the drug because it was clear there's fentanyl and another substance. And then, of course, in September or so, you knew methamphetamine wasn't all.
I have the indictment here, part of the record filed August 17, 2021, the count 2 states Darius Taylor did commit the crime of quote-unquote possession of fentanyl-related compound. And as you read through the statute, as it's pointed out in the indictment, it does state a combination of a fentanyl-related compound and another controlled substance. We do not have a combination of a fentanyl-related compound and another controlled substance here. We only have methamphetamine.
No, but you wanted them to know that there was another controlled substance in this particular case involved, according to the allegations of the state. You didn't just think it was fentanyl, they said it was fentanyl and something else. So now they're asking to clarify this something else is methamphetamine.
Yeah, they're clarifying that the something else is methamphetamine, but the statute and the subsection, in my opinion, does not apply, as it still requires even some sort of trace amount of fentanyl to come back on the BCI for that statute to apply. So he was indicted under the wrong subsection of the statute.
And if I understand you, then you're telling me the records show that it was not until the Friday before trial that there was any mention of amending the complaint.
That is true. I asked what the state was proceeding on at trial on Monday. I believe it was either the Thursday or Friday before, because we did have a conference with the judge and we did work on it over the weekend on Saturday. The reason I asked is count 1 was having weapons under disability. The report came back that the gun was inoperable. So I was making sure that they were not proceeding on that was my question. And I got an email from the prosecutor, Lauren Kitchen, that day that stated we are dismissing count 1, having weapons under disability, as the gun was inoperable and the statute requires the gun to be operable. And she said we are proceeding on amended count 2 of possession of aggravated drugs, I believe, is what she stated.
Counsel, I have 2 questions. Any of that in the record? Is the first one. At the hearing, when they moved to amend, was that in the record in terms of what was said in court?
Yes, we had a phone conference with the judge, and it is outlined in the transcript prior to the trial.
Okay, and then was the weapons under disability count dismissed?
Yes.
Actually, okay. So the only remaining count would be the amended count that.
Yeah, the only remaining count was count 2, possession of fentanyl, felony of the 2nd degree, and count 3, resisting arrest, a misdemeanor of the 2nd degree. When the motion to amend was denied by Judge O'Brien, they felt that they did not. I asked to proceed to trial that day, as the jury had been waiting for almost 2 hours at that point. They felt they could not proceed on count 2 as written, which which is why they sought to appeal. And then also on count 3, eventually my client agreed to just stay that count pending the appeal, as since he already served well enough in time that a misdemeanor of the 2nd degree would, the maximum penalty would be, they did not want to proceed on resisting arrest that day.
Thank you.
If there's any other I don't have anything further unless there's any other questions.
Thank you, Karen.
Just briefly, judges offer quick rebuttal. Defense's theory is that there's completely different drugs here. That's what we just heard. And I just don't think that's the best way to characterize the evidence in this case. If the state had asked to change the amendment count from an F5 possession of heroin to an F5 possession of cocaine, we wouldn't be here today.
I think the point was, though, that it's a different statute. It's totally different. It's not a lesser included of that.
So I think that this is one instance in the drugs where it is a lesser included because of the combination that is referenced in the indictment and the statute. So, and whether there's a different subsection involved, I mean, if that was the case and that was what courts were relying on, we wouldn't have these amendments that I mentioned previously that were authorized under Rule 7.
Is it a different section or a different subsection?
Subsection.
That makes sense.
So with that, judges, I'd ask that you go ahead and reverse the trial court's ruling.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be sent to all parties to this appeal as well as posted on their consequences.